The webinar is hosted by MacDonald Associates, and I have today with me Richa Sandhill, who is one of my associates here at the firm. As you are aware, MacDonald Associates in particular has decided to host webinars and LinkedIn Q&As in order to discuss with you the hot button issues in employment law and give you an opportunity to ask us questions in the half hour that we provide. By far today, one of the hottest issues in employment law is how employers and employees are addressing marijuana in the workplace, and in particular, given the fact that obviously the Cannabis Act is going to become legislation and in place as of, I believe it's July 2018, Rich, is
July
that right?
1st, 2018, yes.
Then we need to be equipped and prepared in order to address it. It's raised all sorts of issues and all sorts of concerns by virtue of how it's supposed to be addressed in the workplace. And of course, it's raised two separate issues, I believe. One is it's raised the issue of how we address medical marijuana, because that is still an issue that employers are grappling with. And on the other hand, it's now going to address the issue of how we deal with actually marijuana that when it is legalized. And that raises a whole host of questions, from everything, including how it's dealt with in a social situation, how it's going to be dealt with if an employee comes high to work. So we're going to have to obviously address this as we go. One of the things that everyone should know is that marijuana in the workplace is going to be dealt in very similar fashion as employers have been dealing with alcohol in the workplace. And you will hear me say this time and time again, and I'm sure you'll hear Richa say this as well, but the most important thing for all employers to have in place in order to embrace this new legislation is their policies. And the policies will not only be beneficial for the employers, but they will in turn be beneficial to employees, because it will allow both parties to know exactly what their rights and entitlements are. So we have had a fantastic response from you folks. In particular, we have a starting question, and the starting question, as I understand it, is coming from Sandra Caputo. So Sandra, thank you very much for writing in. Sandra, you've asked with respect to what one does if one suspects, and I take it this is from the employer perspective. So what does an employer do if the employer suspects that someone is high on weed at work? And I'd like to turn that over to Richa to give us an answer on that and give us her thoughts on how we can do that.
Well, I guess I'll pick up on what Natalie said. What would you do if you suspected an employee was drunk at work? If they showed up and they seemed inebriated? And I think that is probably the best way to treat a situation like this. So if you suspect an employee is high, I think off the bat, you want to make sure they're okay, first of all. You want to make sure whether or not there's any potential safety concerns, talk to them. If it seems like they're particularly inebriated or particularly unable to function, then perhaps you might want to consider sending them home. In all cases, don't jump the gun. And the reason I say don't jump the gun in terms of discipline, in terms of taking any rash action just on the basis of whether or not they're inebriated or whether they're high, is because there may potentially be human rights issues at play. So you ask, is it seen as a disability? Well, a person showing up to work high is seen as a disability, particularly in two main instances. One, if they're suffering from an addiction. The second is if they are required to use marijuana for any sort of treatment or health purposes. They've been prescribed to do so as part of a treatment plan by their doctor or healthcare practitioner. So the risks involved in terms of confronting staff in that type of a situation is that you need to make sure that you approach this person either at the time or when they're in more of a state to be able to speak and to explain their situation, understand their needs, understand why this happened, and then determine if this is a situation that falls into one of those categories, or alternatively, if this was just a situation of a person showing up high to work, which is effectively, it's the same thing as somebody showing up drunk to work. And then, of course, you need to determine what to do based on your own individual drug and alcohol policies in effect in the workplace. But make sure, the main thing is to investigate and to make sure you understand why this happened and why this person showed up the way they did.
I think I agree wholeheartedly with everything Richa has said. One of the further issues I would point out is that, of course, similar to an employee who is drunk or inebriated in the workplace, you have the right to take that person aside and out of whatever situation it is, because, of course, that's a reasonable expectation that your employee shows up and is sober to do his or her work. But after that, absolutely, I think Richa is absolutely right. And I think you need to be gentle about it because of the fact that, you know, there really may be a serious issue at play and you may just be seeing it for the first time. So I think that's great. I think that's great. We got another question. Do you want to read that one, Mitch, that just came in?
Sure. So drug testing. So will this now be seen as more acceptable in the workplace other than those that have actual requirements to test?
And so I think it's a great question, and I think it's come into play as a result of some of the case law that has probably been out there recently, and in particular, I know the TTC had some cases recently. No, drug testing is not okay in the workplace. It's not all right to actually go in and test your employees unless the employee is in a safety sensitive position. And that's when it does become a really serious problem for the workplace. And you want to make sure as the employer that not only are you keeping that employee safe who's working on the equipment, but also other employees in the workplace. Something that we see all the time is employers can't look just at one particular employee. You have to look at the effects and the impact on all employees in the workplace. And obviously, employers have a common law duty to protect employees and make sure that they are safe and healthy. Along those lines, if you've got a worker in a safety sensitive position, you certainly do have the ability to be able to, find out if they are on drugs, be it alcohol or on marijuana. But absent that, you can't just go randomly asking for drug tests. That's still against the law. Absolutely. Another question that came in, as a matter of fact, is now that recreational use of marijuana is going to become legal, should we permit employees to smoke marijuana at the company social gatherings, and the same way that we would permit them to drink alcohol? And I find that interesting because that was one of the issues that Richa and I discussed that we think is going to arise, as a matter of fact, as an issue, and we need to know how to deal with it. Pardon me. Rich, would you like to respond to that question?
Sure, and I mean, of course, I defer to Natalie's opinion as well on this, but my own view is if we're talking about treating this as the same as alcohol, and this is purely recreational use, say, at a social gathering, at a summer barbecue, it really depends on what your individual company wants to do. But I mean, if once July 1st, 2018 has passed, if it's decided that the company office party wants to have weed, and I mean, I'm not sure what the regulations are exactly going to look like in terms of accessing it. The government is still in the consultation process. They're still trying to determine the LCBO type system that's going to govern how we are able to, or how people are able to access recreational marijuana. But if going through that process, I don't see a problem with it. But what I always say about this in terms of marijuana itself is that it's really, when it comes to this aspect of it, it's really an attitude shift, I think, that might also accompany it a little bit, because it's, at the end of the day, if it's purely for recreational, it's the same reason people drink alcohol. It's a social norm. It's a social aspect of the way certain people do things. So, I mean, if it's something that's within the culture of your company, with something that fits within the drug and alcohol use policies of your company, why not? But it's really up to you. That's my view. I mean, I defer to Natalie, obviously.
Well, I would definitely say that one of the issues that I think both employers and employees are going to contend with in a social setting is the idea of the smoke. Mm-hmm. So that's one of the concerns that I would have. And I think, you know, and obviously, you know, smokers have to comply with bylaws and the legislation that's in place currently. I think at a social function, if an individual is in fact smoking marijuana, as in smoking it, I think it's going to have to be separated from the rest of the party, because there may be other individuals at that party who are offended by the smoke blowing into them. So I think there's probably likely going to have to be a special designated area. And I think I'd like to point out in particular that employees are going to have to monitor employees who are smoking marijuana in the same manner in which they do with employees drinking alcohol. And at social functions, and it's interesting because we're just about to jump into party season, right? We're just about there. I can't believe we're in November already, but anyways. And it seems like, you know, the same types of issues are going to apply. For example, employers are going to have to ensure that their employees don't become inebriated. You know, I love it at a Christmas party or a holiday party. There's always that one employee who wants to tell the boss exactly what he or she thinks of the boss. That same thing can happen with an employee who's high on marijuana. Don't do it. Don't approach your boss at an office party. I think we would say that.
We start getting into discussions of just cause, and we don't really want to go there.
That's right. Exactly. And I think what we want to do instead is, you know, so watch and make sure that that employee does not get into a vehicle, has a safe ride home. If in fact that individual who's smoking marijuana is in fact, you know, too high, make sure that that person is accompanied by someone else to take them home safely. Make sure you provide food at your parties. Make sure that you don't just make it an alcohol or an alcohol/marijuana event, and make sure that you sort of, I'd like to say, gauge the temperature of the room and watch your employees to see that they are all comfortable, because it's important that, you know, you make sure that you're monitoring the situation. Social functions are wonderful. We have them. We love to have them. I'm sure everybody out there loves to attend them. But you've got to apply the same rules as you would in the office. I mean, you let your hair down a bit, but not that much. It's not the time to, you know, tell your coworker you're in love with her or him at the time, right? So it's very important that employers follow that same protocol, I think. Absolutely. Another question that has arisen, I think, for us, and Rich, perhaps you may want to refer to that one.
Sure.
That just came in.
Our company works with safety-sensitive tasks, including operating heavy machinery. Am I, and I'm assuming this is an employer asking this, so am I still required to accommodate an employee who requires medical marijuana? So in a safety-sensitive situation.
Okay. So just going back to what we've said, if you're in a safety sensitive position, you have the right to ensure that your employee is not high and not drunk. And if your employee is, regardless of whether or not your employee needs medical marijuana for that, there is an absolute ability on the employer's part to take the employee away from the safety sensitive equipment that he or she is operating and accommodate them in a different way, but don't allow them to operate that equipment. We've talked about human rights issues. We've talked about, obviously, we've touched on just cause. I'm going to bring up a really serious issue as well, which is criminal code charges for a death in the workplace. That is not a situation that you want to find yourself in as an employer or an employee. And if you allow someone who is inebriated, either by way of medical marijuana, or alcohol to operate, you may find yourself in that situation. So please don't hesitate to pull that person off the machine, and then discuss how you can actually go about accommodating them. Because there are all sorts of ways in which to do so, and it does not have to impact the job. It can be done at several different junctures within the daytime, and it can be done in a safe manner. Do not be afraid to work with the employee and the employee's doctor to make sure that you can find the safest, most accessible route in order to ensure that that employee feels comfortable. And one thing, I spoke at the O-Cannabis conference as well when it was on, and I can tell you that I learned so much from all the wonderful vendors who were there about various ways in which to ingest marijuana and not have to smoke it, and also different levels of it, different strands of the actual cannabis, which can do the same job for an employee in a different setting. So I highly recommend that all of those strategies are actually investigated. Now, we've had some terrific questions from employees as well. And I know that one of them came in actually, which is from an employee. I'm sorry, we don't know who, but it says, I work at a zero tolerance facility, but I have a medical marijuana prescription. Should I tell my employer? What will they do? Rich, I'd like to turn that over to you to answer for the audience.
So yes, tell your employer, because this is going back to the first question that we were answering for an employer about whether or not marijuana use is a disability. This may be one of those situations where if you have a medical marijuana prescription, to me that sounds like you need it for a medical reason to treat something. Your doctor's given this to you, that engages a human rights concern. That may mean that your marijuana use falls under the broader category of the broader protected ground of disability under the Human Rights Code. If that is the case, then an employer, if they learn of this need for medical marijuana, is under a duty to accommodate you up to the point of undue hardship, which is a pretty relatively high standard for employers to meet. So zero tolerance facilities, I mean, I'm assuming maybe there's perhaps a safety sensitive risk at play in this particular workplace, or the drug policies have been designed as such that there is zero tolerance for drug and alcohol use. And of course, it's like we said in the beginning, we're showing up to work drunk, showing up to work high for no reason. We can understand why that would be a concern for any employer, but your situation is a little bit different, because if you have a prescription, you have an accommodation need, you should be telling your employer. As soon as they learn of it, what they should be doing, if they are well advised, they will start making inquiries into what they need to do to help accommodate your needs under this prescription, and assist you in being able to continue to carry out your job. If you have a medical marijuana prescription, I mean, that could mean that you need to ingest it or smoke it or take it at different points of the day. It could mean that you use it once a week. It could mean that you take it and you need it to the intensity that you might need modified hours in order to be able to deal with the effects of it. In all situations, tell your employer, because if they know what they should be doing, then they should make all reasonable inquiries as soon as they get this information from you to be able to see whether they need to take any of those measures. If they use their zero tolerance policy to take disciplinary action against you, dismiss you as soon as they learn of a medical marijuana prescription, without making those reasonable inquiries, then I mean, that's a situation of reprisal against you for bringing forward a human rights need, and rather than making reasonable inquiries into how they can accommodate that need, they instead decide to take action against you, and that's rather the type of situation where the Ontario Human Rights Code tries to come in and protect employees who are asking for those types of needs. So our next question is, what should I do if I think my colleague is impaired from having smoked marijuana today, but I don't know if he's got a prescription? Will I get in trouble for bringing this up to my supervisor?
Well, this is a great question, and I can say most clearly that if you're the employee, I want you to go to the company policy, which should be in place. If it's not, I'm going to discuss the fact that this will be the most important document that needs to be created by the company in order to handle and address all of these issues that we're discussing. For the employee who's asking about this, you don't know whether or not he has a prescription. You are absolutely right to want to raise that with the company, because you have a duty to protect the company as well and act in the best interest of the company. Will you get in trouble for bringing it to your supervisor? Absolutely not. Unless it is motivated by malice, unless you're being malicious in what you're doing. And if you're doing that, yes, you will get in trouble, and likely you will be disciplined or in fact terminated from your employment, potentially for just cause. But certainly do not expect to get in trouble for raising an issue legitimately and genuinely that you have as a result of seeing one of your colleagues high in the workplace. There's nothing wrong with that whatsoever. And I've already spoken about that, but I think it bears some further discussion. And this, again, is something that is important for both employers and employees, but for the workplace in general. Employers, you must have a drug and alcohol policy. You must have one contained within the employee handbook. If you have that policy in place right now, don't leave it on the shelf. It has to be updated on an annual basis, and it must be compliant with the times. And the times, as Bob Dylan said, they are a-changing. They really are. And so now what we have to do is we have to make sure that we are outlining in our policy the proper terms and conditions that are going to be necessary to deal with these issues. The first is we're going to want to ensure that we've got prohibitions in our policy. We want to ensure that there's a very good blanket statement that all employees are prohibited from drug and alcohol use before and during work. All right, that's very, very important. Requiring employees to disclose information about any prescription drugs, which they require, is also an equal prohibition that should be contained in your policy, as is the fact that if prescription drugs or marijuana is going to be used in the workplace, the employer must know, and the employer will in fact accommodate up to undue hardship and with dignity and respect. Don't forget dignity and respect. It's something that I always see not included in policies, because I think we're so busy trying to put into our policy the accommodation. The Human Rights Code equally requires that employees are accommodated with dignity and respect. And so whatever can be done to assist in that regard is something that employers must be cognizant of. Also in your policy, you're going to want to outline your reporting mechanisms. So we're going to ensure that we have one process available for accommodation and for obtaining medical information, maintaining confidentiality and privacy, and expecting that an employer is going to be able to assess options for accommodation. Remember, I spoke earlier in this webinar about ingesting or modifying, sorry, I did speak about ingesting marijuana, not just smoking it, but also you can modify the hours of work for the individual. You can provide a leave of absence if that's something that is required. And finally, in respect of your policy, you're going to want to have a section dealing with consequences for that breach. And consequences may be as minimal as simply discipline in the workplace, but they could also range from that to termination without cause or with cause in extreme situations. And you want to ensure that your policy is broad enough so that it's not so narrowly defined that everything is completely constricted with the policy. You don't want to do that as an employer, because it will obviously obliterate any latitude and flexibility you have in respect of your policy. So I think it's very important to have that. So for the employee who asked about whether or not he or she was going to get in trouble, there should finally be a mechanism in your policy that says reprisal is not allowed, and it is prohibited for anyone who comes legitimately with a complaint that an employee is either inebriated or alternatively high. And so for the employee, you can look at that policy and you can see quite clearly in black and white that you will not get in trouble. And so obviously, once again, these policies are going to benefit both the employees and the employers. I see that we're just reaching the end of time. I would like to thank everyone today for tuning in. I think Rita and I very much enjoyed our discussion, and it was something that we all hope you were able to benefit from. I would like to leave a few words for employers and employees, something that I think is very important and that I've come up with to assist you as you continue to navigate through these turbulent waters as we go through with marijuana in the workplace. I think employers should adopt the P.O.T policy, beginning with capital P. Have a policy in place on drug and alcohol related issues, all of what we had discussed today. The O in P.O.T stands for the obligation upon employers to accommodate and engage employees. The T in P.O.T stands for training employees on your policy. Train your managers so that they know how to deal with this important issue and they know how to navigate it properly. For employees, I want you to follow the W.E.E.D policy. Without a prescription, there is no accommodation. So don't try and find an employer and say, I need to be accommodated without having that prescription. That's the W in W.E.E.D. The E, the first E in W.E.E.D is engage with your employer if accommodation is in fact required. The next E is ensure that your employer is aware of your need for accommodation. Can't tell you how many cases I have defeated where an employer, I've acted for the employer, and the employee has not told us that they needed to be accommodated. The easiest defense for an employer is to say, we didn't know that. So employees, ensure that your employer knows that you need to be accommodated. And finally, with D in the W.E.E.D policy, disclose all medically required prescription drugs. Very important that your employer knows about that so that they can assess and act accordingly. So folks, we will continue on with our next webinar next month, and we will be sending you out, as we have always done, the post in respect of that, and look forward to you joining us. On that note, it will be about sexual assault in the workplace, and it will be hosted at the beginning of the month as usual. So thank you all. If you have questions on the upcoming topic, please feel free to forward them to social media at MacDonaldAssociates.ca. I should know the email of my firm. Excuse me for that. It's social media at MacDonaldAssociates.ca. There is no "and" in there. And we look forward to seeing you next month. Thank you very much and have a great day.
Thank you.
Thank you.